Hello, good afternoon. Thank you so much for joining us this afternoon. My name is Raina Kessler. I'll do a quick introduction of myself and then introduce our panelists today, Roger Slade. Like I said, my name is Raina Kessler. I'm a partner at the law firm of Robins Kaplan. We're a national law firm that has offices all across the country. I'm licensed in New York, New Jersey, and Pennsylvania, and I specialize in personal injury law. I mostly do medical, drug, and device law, representing individuals that are harmed by defective products. I also work on sex abuse litigation involving religious institutions due to laws that have changed in New York and New Jersey that allow survivors to bring claims regardless of the statute of limitations. So I'm very happy to be here today and learn more about domesticating out-of-state judgments in the state of Florida. I've been spending some more time down in Florida during the pandemic, so I had the honor of meeting Roger Slade a few months ago, and we kind of came up with this program as a good way to collaborate with different areas of law around the country. Certainly, we've all experienced times when we have to enforce judgments in different jurisdictions, and we all know that Florida is a very debtor-friendly state. So I'm excited to hear what Roger has to say and his advice on making sure that we can enforce judgments within the state against Florida residents and corporations. So with that, I'll do a quick introduction of Roger. Roger is a shareholder with the Miami law firm of Haber Law. He has over 30 years of litigation experience. He has litigated cases all over the United States in Florida, New York, California, and many other states. Roger has also defended several appeals in the United States Supreme Court. Roger is a member of the Florida Bar, the New York Bar, and the Connecticut Bar. He is a Florida super lawyer 10 years in a row, and he is currently the president-elect for the Miami-Dade Bar. Throughout his career, Roger has handled all types of litigation matters, including business fraud, class actions for both plaintiffs and defendants, real estate litigation, privacy litigation, commercial collection matters, employment discrimination claims, general business disputes, and international family law matters. Roger has collected millions of dollars on behalf of his clients and has extensive experience enforcing out-of-state judgments throughout the state of Florida, which we'll discuss today. Roger graduated at the top of his class from Brooklyn Law School, where he was the managing editor of the Brooklyn Law Review. So thank you so much, Roger, for sharing your experience today, and take it away.
Thanks very much, Raina. Appreciate it. Welcome, everybody. Today, we're going to talk about a topic that I consider to be somewhat fun, which is how to enforce judgments from other places here in the state of Florida. And when I say other places, what I mean is any judgment that is outside the state of Florida, and that includes judgments from other states in the United States and judgments from other countries. Now, this is a very popular topic here in Florida and has been the subject of a lot of litigation for a lot of reasons. One of the main reasons is that, as Raina mentioned, Florida is a very debtor-friendly state. People tend to come to Florida in order to flee creditors, hide their assets, and basically escape from bad business deals, divorces, and other things to come to the state of Florida. So our firm is consulted on a regular basis about how to find assets and how to enforce judgments. And so what I want to talk to you about today is this general process of how this works. I'm going to try to put it in two perspectives, one of which would be maybe somewhat legalistic and another for the lay person, so that you're going to understand how this works. And I'm going to try to also explain it from two perspectives, from the perspective of a person or business entity that wants to enforce a judgment in the state of Florida, and also from the perspective of somebody that wants to resist the enforcement of a judgment in the state of Florida. I'm going to talk a little bit about how to collect your money, how to get money out of debtors in the state of Florida in light of all of the restrictions that apply, because as Raina said, this is the most debtor-friendly state in the United States, and that's one of the reasons people come here in addition to the sunshine and the beach. So let's talk about this. Let's talk about the types of judgments we want to consider enforcing and what the defenses could be to that. So Raina, if you would turn to slide number 2 on the PowerPoint. it talks about how you take a judgment from a foreign state, and for the purposes of Florida law, a foreign state in the United States. And as you probably know, there are legal proceedings which take place all over the United States, and from time to time, a debtor or defendant relocates to the state of Florida. And in order to enforce your judgment that comes from, let's say, Illinois, for example, you have to do something called domesticate that judgment in the state of Florida. Now, there's a statute that provides for that to enforce. Basically, it's called the Florida Uniform Out-of-Country Money Judgments Recognition Act. And that's basically a fancy way of saying, how do you get your judgment to be enforced in the state of Florida? Now, for the United States, all 50 states have something that unifies them called the United States Constitution and something called the Full Faith and Credit Clause. And if you're not familiar with that, I don't know how many lawyers we have on the line, but the Full Faith and Credit Clause basically requires the state of Florida to recognize judgments from other states. Now, that doesn't necessarily mean that they have to recognize all judgments. Those judgments can be subject to attack under certain circumstances. You can contest them. But the presumption is when you come with a judgment from another state in the United States into the state of Florida, that a Florida judge and a Florida court is going to recognize that. Now, the way it works, as you'll see on page 3, is it's a very simple process to have your judgment domesticated in the state of Florida. Basically, you just have to record it. And you provide notice of the recording once the judgment is recorded in the clerk's office, like a lien, for example, like a mortgage or a deed. And then a notice is provided to the debtor or the person who the judgment's being enforced against, which gives them an opportunity to come in and contest the judgment. Now, in a lot of states, for example, in New York, when you obtain a judgment here in Florida on default, New York State does not really recognize default judgments, and you have to start the process all over again. Here in Florida, most of the time, we will recognize default judgment, and that will be subject to being recorded. There's a process that's available, which you work with the clerk of the court. Now, of course, in the old days, we used to come down to the courthouse and march down to the clerk's window with our papers and get a stamp on it and write a check. But we're past that stage now. Now we do everything, of course, online. So we have to prove, in order for the judgment to become effective, that it was registered here in the state of Florida and that we sent a mailing notice to a judgment debtor. And of course, then the judgment debtor has time to come in and object. Now, there's all sorts of reasons that people will come into court and object to a judgment. There's a way it's done. If we look on page 5, it discusses specifically a manner in which a judgment can be contested. In certain instances, it requires a debtor who's contesting a judgment to file a complaint and basically start a court proceeding. And then explain to the judge why the out-of-state judgment is not enforceable. And there's a whole series of rationale for objecting to an out-of-state judgment. And as a plaintiff's creditor's lawyer, which we are most of the time, we have to get over those barriers and those thresholds. There's usually an initial hearing that takes place with the court, and the judge will inquire as to what the rationale is for contesting the judgment before it becomes effective. And I'll talk in a little while about what happens when the judgment becomes effective and what your remedies are as a creditor to collect money once you have an effective judgment. So there are certain requirements to meet, and we have them set out on page, I think the next page is 6. And how do you contest a foreign judgment that's been filed in the state of Florida? Well, there's a lot of funny business that goes on in the courts outside the state of Florida, just like there is here. And sometimes you have judgments that are fraudulently confirmed or confirmed without having notice provided to the defendant. So the first time someone gets notice of a judgment is when the judgment is recorded here in Florida. Perhaps they weren't served with process. Perhaps there was defects in the complaint originally filed in the out-of-state court. And this is something that debtors look to and they utilize to create issues and prevent the judgment from being enforced. So what that really does is that creates almost what I would call literally like a redo or a do-over, where the in-state debtor in Florida gets to contest all over again the judgment that came from another state. So what I tell people sometimes when they are thinking about bringing lawsuits, even though they may have a forum selection clause in their contracts, or even if the debtor or defendant was doing business in the foreign state, let's say Illinois, New York, California, but you know that the debtor lives here in Florida, sometimes it's better to just skip over that step of litigating in a place like California or Illinois and just bring the lawsuit here. Because unless you have a consent to jurisdiction, there's always a battle about whether there's minimum contacts with the debtor with a place like California or Illinois. And if you know the debtor is here in Florida and you know the debtor has their assets here, I would suggest that it makes sense to start the process here. This way you avoid the entire concept of having to domesticate the judgment, and particularly in a case where you think there may be a chance you're going to have to litigate the thing all over again. So there's also issues to know about statute of limitations. You can't let your judgment sit forever. If you have a judgment from a foreign state, California, New York, Illinois, you can't leave it sitting there for 6 or 7 or 8 years. There's a statute of limitations to file an action, and the judgment here in Florida only usually lasts 20 years. So in representing creditors over the course of many years, there's one thing I always fall back on, and that is this concept that the diligent creditor is always rewarded. The creditor that sits on their rights and does nothing is almost always punished. And that's because there's rules in Florida and other places that the first creditor to reach the assets gets the assets. You can literally leapfrog over other creditors who may be in line before you. So it pays to be diligent. It pays to file your papers timely. It pays to enforce your judgments very quickly as you possibly can. In this way, you also have the best opportunity to ensure the fact that you're going to collect money. Now, this is not to suggest that you can't collect on old judgments. And I'm going to tell you just a war story, which is one of my favorites about collecting judgments. We had a gentleman come into our office maybe 15 years ago who had a Florida judgment. Maybe I would say it was about 5 or 6 or 7 years old at that point. And the gentleman showed us the judgment. It was for $350,000. And he said, do you guys want to take this case on a contingency and to see if you can collect some money from it? So we agreed to do that, which is maybe something we may be more circumspect about doing today, but back then we did it. And even though the judgment had been of record for a long time, the plaintiff and our client did not have any knowledge about where the debtor resided, although he knew he was in the state of Florida. And I remember him telling me that the last he heard about this gentleman was that the gentleman was literally sleeping on other people's couches because he had no money. He was a stockbroker. He had run off with $350,000 of our client's money and basically asked us to take a flyer on the case. So we did. We did a people search. We hired an investigator. We found the gentleman. We served him with what we call post-judgment discovery, not thinking that we were ever going to get anything out of this. We figured that what our client had told us was true, that the debtor was poverty-stricken, sleeping on someone else's couches. So what ended up happening, and this is, I think, the moment that we knew we had something, that we had a fish on the line, was when the debtor hired a big law firm to file an emergency motion to vacate the judgment and came in and raised all these issues that a prior lawyer maybe didn't see. At that point, we figured that this debtor must have assets. And we were able to settle the case for almost 100 cents on the dollar. So I guess the first rule is to be diligent and not give up. Because even though there's a passage of time, you can still collect if you are patient enough and diligent enough.
Along those lines, Roger, if I could ask a question real quick. What about when it comes to personal jurisdiction and enforcing judgments in Florida? That's been a really hot topic with the Supreme Court. It's come up a lot in our product liability cases with international corporations specifically, especially in a case where there's multiple defendants that might have judgments against them.
Well, you always have to and you always have to be able to establish personal jurisdiction in the forum state. So there has to be, in all cases, minimum contacts. So most of the time, you're not going to domesticate a judgment in the state of Florida unless you feel that the debtor is currently residing there. And if the debtor is residing here, it's almost an automatic right to enforce a judgment. Now, or if the debtor has property here, that's another ground. We've had people assert motions to dismiss and claim that there's no jurisdiction here in the state of Florida, but meanwhile they own bank accounts here and they have money in the bank. I think that's a sure telltale sign that the debtor is doing business here or is transacting business here, which is enough to satisfy the statute. Interesting thing about Florida judgments, and one of the things that's most noteworthy and the most challenging thing, it's been the subject of many news reports, is this concept of a homestead homestead exemption. And you'll see, if you could turn to page 7, that a judgment lien, which once it's domesticated, can become a lien on real property. So that applies to certain instances. It doesn't apply usually to a debtor's homestead. The state of Florida protects the homestead of individuals who have established the right to a homestead exemption through a procedure we have here in Florida by filing a homestead declaration, making sure that their application is accepted, and that property is usually exempt from creditors. However, many debtors, people who come to Florida, also have investment properties, either through corporations or owned individually, and those properties are not exempt from creditors' process. So once you get a judgment and your judgment's recorded in the state of Florida, you can actually foreclose on a debtor's property that's not encumbered by homestead. It also allows you, once you have the Florida judgment, to lien and execute on personal property, which can be a little bit more dicey, but sometimes you can hit it big with that too. And that allows you to levy bank accounts. You can serve writs of garnishment, take money from bank accounts, subject to exemptions, which I'll talk about in a minute. But once you levy on bank accounts, that's a good way to get cash. You can have the sheriff enter someone's unit or property. There's something called a break order that allows the sheriff to go into someone's home and essentially count out the jewelry and take the jewelry, or whatever things of value may be in somebody's home once you have a judgment. Now, of course, the debtor has lots of exemptions here in Florida, something called head of household, which limits the amount of income that you can take from a debtor, but it doesn't really prevent you from taking hard assets like cars, boats, planes, jewelry, cash, and that is something that can really be very fruitful if you're trying to collect a judgment. So your judgment lien, once it's domesticated in the state of Florida, can really serve as a basis to collect money. And there's a whole series of steps we take in order to ensure that we can collect money timely, and we'll talk about that as we go further along.
Roger, what about bank accounts? Is that part of?
Yeah, bank accounts are something that is a special challenge, because even though there's investigators out there that'll tell you that we can find bank accounts for people, and sometimes it works, it's really against the law for an investigator to do bank account research on somebody surreptitiously. So when you're looking at bank accounts, we usually start with the banks where we know the debtor usually banks. Or alternatively, what we'll do, since there's a limited cost to serve writs of garnishment, we'll serve writs of garnishment sort of like machine gun fire across 10 different banks to see if we hit something. And that happens all the time, where we're able to locate assets. I think it's about $100 a piece, or maybe $50 a piece to serve writs of garnishment. And if you have a judgment that's big enough, it would be worthwhile to sort of scatter your writs of garnishment across several different banks. But of course, it's difficult to do that. Now, when you have a judgment entered in the state of Florida, particularly like a regular judgment, the court requires you to fill out something called if you're a debtor, to fill out something called a fact information sheet. And in the fact information sheet, you have to provide the court and the plaintiff's lawyer with all information about all of your assets. And one of the reasons for that is to avoid the problem of trying to force the debtor to reveal what their assets are. I think the courts have had a tremendously difficult time in convincing people to, voluntarily reveal that information. So that's normally the subject of several court hearings, motions to compel, contempt hearings, and things of that nature. And of course, it depends on the nature of the judgment and the amount of the judgment as to whether it's worth it. For a $15,000 or $20,000 judgment, may not be worth it, but for judgments that are significantly more, like our firm just got a judgment against a defendant for about $1 million. We've been in court forcing the defendant to produce his bank records and his financial statements and his tax returns. And ultimately, we know we're going to collect on that case because the debtor is still working and still active. But we'll talk more about that as we go forward a little further in our webinar. I wanted to talk a little bit about what happens in connection with foreign out-of-country judgments. So if you wouldn't mind, Raina, turning please to page 9. Out-of-country judgments are really more my favorite thing to do because it's just an interesting aspect of the law. The difference in Florida between a foreign judgment and an out-of-country judgment is that foreign in Florida law refers to another state in the United States. I know it doesn't make sense, but that's how it reads. Out-of-country judgments refer to judgments of a foreign state other than the United States, and that includes places all over the world. So you can, in certain instances, take a judgment that was rendered in another country and have it domesticated and recognized here in the state of Florida. So I have dealt with judgments from other countries. Specifically, what comes to mind, I had a judgment from Taiwan, a judgment from Russia, judgments from Chile, and judgments from Egypt that people have come to the United States to try to have recognized. And the procedure is very similar to having a judgment recognized from another state in the United States, but it raises all sorts of different issues. The procedure for domesticating is simply by filing, if you could turn to page 10, please, a certified copy of the judgment in the county clerk's office. The same notice is sent, more or less. And then the defendant or the debtor has opportunity to contest that judgment in very much the same way that an out-of-state defendant can contest the judgment. But the thing that's interesting about foreign country judgments is, of course, every legal system in the world is different. They don't necessarily have the protections that we have here in the United States. And for example, in Taiwan, there is no such thing as discovery. What happens in that case, and it actually kind of makes a little bit of sense. And maybe if there's some United States American litigators on the line, they may appreciate this. But in Taiwan, it's the judge that conducts the discovery. It's the judge functions as a judge and an investigator. Now, is that consistent with our notions of due process? Of course, for all the Florida lawyers on the phone or the litigators that are on the phone, we love litigating our discovery issues. What's the scope of discovery? Where can you look? But in that case, it's the judge that takes care of it. So, but the interesting things that come up in connection with out-of-country judgments is whether the out-of-state party or out-of-country party was afforded due process. Due process, of course, is a factor of our United States Constitution that we have here in America. But guess what? They don't have that in other places. And that's the great thing about this country. They do not have due process in most places in the world. And because of that, creates all sorts of issues about whether an out-of-country judgment afforded the plaintiff who wishes to domesticate the judgment, or rather the defendant who wishes to contest the judgment, whether they were afforded due process. And what does that mean? Okay. Sometimes there are judgments which are just repugnant to the foreign policy of the United States. For example, in the country of Taiwan, which involved a judgment that I litigated, it was a divorce case, there's no such thing as alimony. A party who's getting divorced, who is dependent upon another party, is not entitled to alimony. And in order to ensure the effectiveness of the divorce, they filed the judgment here, and they wanted a court to determine that there was no basis for alimony. Yet that is an issue that directly conflicts with Florida law, for example, which has a very rigorous and well thought out alimony scheme, which provides for alimony for a dependent spouse. So how does that really work if you can get a judgment in, for example, in Asia that eliminates alimony, yet the foreign spouse resides here? Well, it creates a burden. It creates a burden on the United States courts, and there is an argument to be made that that judgment would be found to be void because it did not consider the essentials of what we would consider to be something required by due process. One of the big issues in foreign divorce cases is notice, and all foreign litigation. You know, we have a very strict scheme about service of process. You need to have the process server come to your door with a piece of paper and hand it to you, or you need to be served by publication or something else. But it's not as rigorous in other places. And so one of the things that a good Florida lawyer will do when analyzing whether a foreign judgment is enforceable is to determine whether the party against whom enforcement is sought was really served. Because I've had cases where people come to my office and they say, I got a copy of this judgment in the mail. I was never consulted about this. I was never served. I never hired a lawyer. I never appeared in the case. I never contested it. How can they come here and try to enforce this judgment against me here in Florida? That's a significant issue. So I think in order to enforce a judgment, you have to make sure that you follow the steps. In other words, if I was giving a client advice about getting a foreign judgment and enforcing it here, I would try to make sure that service of process and notice was conducted in the way we do it, so that an American court will look at it and say, well, this was fair. This was the way we do it. But there are lots of ways to contest foreign judgments. One of which, if you turn to, I think, page 13, we talk about the fact that there's an agreement between the parties which the judgment runs contrary to. So the interesting thing about that point is that that almost gives the defending party, the defendant in this case, resisting the judgment, the opportunity to say, this judgment should never have been entered in the first place. So that creates an issue because it almost opens up the entire ball of wax all over again. So it's almost as if the foreign judgment has no meaning if you could make that argument. There's also issues, and the case I worked on involving Taiwan was interesting because in Taiwan, they make the determination about their right to jurisdiction based upon the citizenship of the parties, not their residence. So for example, in that case, our client had not lived in Taiwan for a significant period of time, but had not renounced her citizenship. The Taiwanese court found that it had jurisdiction over her regardless of where she lived. So here in the United States, that would be a big no-no for a lot of reasons, because citizenship is only one basic indicator of whether you can obtain jurisdiction over someone. I mean, here in Florida, you want to obtain jurisdiction over an individual, you have to be able to show that they live here, that they do business here, that they have bank accounts here, that they own property here, and that there's a regular and systematic course of conduct. It can't be just 30 years ago you were a citizen or you had a Florida driver's license and bang, tag, you're it. So there was a big battle over that issue. And so those are things that the Florida courts are going to look at. If you turn to page 14, one of my favorite ones is defamation. And for those of you who are non-lawyers, defamation means libel, and when you basically say something pejorative or nasty about someone in the press, they have a right to sue. And in the United States, the rules are very tight about what types of judgments you can get in a libel case. And that's because we have the First Amendment, which allows people to speak their mind and say what they want. And we have a free press. And if you read the National Enquirer or papers like that, or you watch some of these television shows, the gossip magazines, you'll see that almost anything goes here in the United States. You can almost say anything about anybody. But you know what? That's not the case in a lot of places. For example, in England is well known for having very strict libel laws, almost strict liability. If you say something about someone in England, and I'm not an English lawyer, but this is what I understand. If you say something about someone in England turns out to be false, you can get a judgment, you can go to court, and you have a judgment entered against them. I think Meghan Markle recently did that. She sued a newspaper for that. But can you enforce that judgment in the United States? Probably not, because it conflicts with our public policy. Our public policy basically provides that we are entitled to a free press, freedom of speech, and you have to prove in cases involving public figures actual malice, which is a standard that's currently being discussed as a possibly abolishing it. I know there's been some Supreme Court opinions in which some of the Supreme Court justices have said that based upon the current status of social media and the internet, it might be time to revisit that. Hasn't happened yet, but right now it's the law of the land. But so for that reason, it's unlikely that a British defamation judgment or defamation judgment from another country is likely to basically stand up here after being contested. So there's a whole series of things that you can utilize to contest foreign judgments. And also, you can also consider having them domesticated here. Obviously, if there's no opposition, it's a lot easier to do that. I represented a woman who had a divorce judgment from Russia. And the way that worked is the divorce judgment gave this wife a percentage of her spouse's income for a period of years. That's mostly different than what we do here. We don't really compute in percentages in divorce cases. What we do is we basically make an assessment of the total amount of income, and there's basically a number that's arrived based upon statutory factors. But she had this judgment that gave her a percentage of his income, and so we made efforts to collect on that judgment, which was difficult because as soon as we filed our motion to domesticate the judgment, this individual fled to another country. So the gentleman was on the run. As far as I know, he's still on the run. So that's the sum and substance of the process for domesticating out-of-country judgments, foreign judgments from another state. And it's a simplified version, but each judgment has to be assessed on its own merits. One thing to bring up, if there's any New Yorkers on the line, is an issue we had with respect to something in New York called a confession of judgment. We had quite a lot of litigation over that. That's a procedure in some states in which a debtor will agree in advance to an amount that they owe if there's a default, and that there's no need to go to a court proceeding and get a typical judgment. Basically, it allows the creditor to simply record the judgment, for example, in the state of New York. Now, that type of arrangement, that vehicle, confession of judgment, is illegal in the state of Florida. You are not allowed to do that. But if you have a confession of judgment from the state of New York, the state of Florida is obligated to recognize that because of the full faith and credit clause. So that has created a tremendous amount of litigation here in the state of Florida about people who default in New York, have given confessions of judgment. The confessions of judgment are recorded in the state of New York, and then there's an effort made to domesticate it here. So you really can't attack it based solely on the fact that it's a confession of judgment. You have to find other means to do that, and we had a long litigation over that. In fact, part of it's still going on. So all sorts of interesting legal issues and practical issues come up when you talk about collecting judgments, domesticating judgments, whether they're from another state in the United States or from someplace outside the United States. But I also wanted to talk about, and I touched upon this a little bit earlier, post-judgment collection processes and what we do here in Florida once we have a judgment that can be utilized. So if you wouldn't mind, I think we're on page 15. Yeah, we're on the right page. So this is what happens after you have a judgment entered in the state of Florida. You record it in the public records. It becomes a lien upon real property. You record it with the Secretary of State. You have something called a writ of execution issued, which will go to the sheriff. And then you are then in an event called an asset hunt. Not an Easter egg hunt, but an asset hunt, where you have to try to track down the debtor's assets. I mentioned before that there's something called a fact information sheet that the debtor is required to fill out, but most people don't. And you have to force the debtor to go back in court to fill out the fact information sheet, which is why we serve subpoenas ducis tecum. The subpoena ducis tecum is a document that's served on a debtor and lists a series of documents they're required to produce. It's a laundry list of things regarding their assets: bank accounts, certificates of title for cars, boats, planes, list of furniture, the whole, everything imaginable that you can think of. And the debtor is required to bring those documents to a deposition in which we get to question the debtor under oath about assets. The sheriff here in the state of Florida, particularly in Miami-Dade County, has been pretty busy lately. So there's almost always a list of people ahead of you trying to execute upon assets, but the sheriff can be very effective. And unfortunately, you'll see that people who have judgments entered against them are not really the most diligent people. They're not the kind of people that take care of business and pay their bills on time. So we had a case recently in which we had a judgment against the copy service, and it was not until the sheriff came out with the trucks and was about loading the copy machines onto the truck that the debtor came forward to pay the outstanding judgment. But you have to work with the sheriff is the point, and after you locate the assets. There's a process for doing that, which basically our paralegals handle, about how to obtain a writ of execution from the clerk. That's set on page 18. And how you get the writ of execution issued. And there's a certain way to levy on assets once the judgment is recorded, which is set out on page 19. There's also a neat procedure here in Florida, which we call proceeding supplementary, motions for proceeding supplementary. I don't think that they have this in most states. When you have a judgment that's not been satisfied, you are technically allowed to implead third parties to whom the debtor may have transferred assets. In other words, we have a case right now where we have $1 million judgment against an individual, and amazingly, after the judgment was entered, he conveyed his home outside the state of Florida to a third party for virtually no consideration. I know you may find that shocking, but that in fact did happen. So we are able, through proceeding supplementary, to implead the transferee, in other words, the party that received the deed and now is the owner, to force them to put that property back into the pot. So these proceedings can take place in court. The debtor will come in and be forced to testify before the judge under oath. And the judge will question the debtor right in front of the lawyers and right in front of their own lawyer. So that's an interesting, it's an interesting procedure that gives us an added advantage.
Roger, for that type of procedure, does it matter what type of case it is in order to use the proceeding supplementary?
It doesn't matter what kind of case it is, because the interesting thing about it is that once your case is reduced to a judgment is a judgment is a judgment. They're all kind of the same in a lot of ways. I'm talking about monetary judgments now. I'm not talking about judgments for specific performance or temporary injunction type judgments. But monetary judgments, it almost doesn't matter what the underlying basis is. Once you have a monetary judgment, you're entitled to utilize proceeding supplementary. Turning to page 25, I know we're coming up to the question period here. I wanted to talk briefly about the diligent creditor rule, which is, I think it's a rule of practice in law for lawyers to use in all sorts of ways. Basically, the diligent creditor rule says that the person who finds the assets first gets them. Now, you have to be concerned also when you are a creditor about prior perfected security interests. I mean, you're not going to leapfrog over a mortgage holder. That's probably not going to happen. Or someone who has a perfected security interest in assets or real property. But for the most part, the diligent creditor rule does allow you to leapfrog over most other creditors. And to be perfectly honest with you, most creditors are not diligent. So they allow you to do this. And so if you really have an insight into where debtor is keeping their assets, whether they're bank accounts, cash, jewelry, cars, boats, planes, whatever it might be, it's in your interest, in your client's interest, to push as hard as you can and as quickly as you can to get at the assets. There's also a writ of garnishment procedure, which I talked about, which is on page 26. If you have a judgment, you are entitled to levy upon property that's in the hands of a third party, and the most common thing to do is bank accounts. But of course, you got to find them. So that's, again, the machine gun approach that I spoke about before. There are some investigators who will promise you that they can locate bank accounts. I would be careful about utilizing those folks because you really don't know how they do it. And if you do utilize them, I think you should just ask them to just tell you the results. Don't tell you how they did it, because it is probably a violation of federal law to inquire, for a third party to inquire about the location of bank accounts. Of course, the debtor is supposed to tell you where the bank accounts are by filling out the fact information sheet. I talked about the homestead exemption. One of the things that makes things really hard here in Florida, because what ends up happening, and you may have seen a 60-minute story on this many years ago. I don't know if anybody remembers or is old enough to remember the baseball commissioner, Bowie Kuhn. Became a partner in a law firm in New York after his tenure as baseball commissioner ended. And the law firm was called Finley Cumble. And ultimately what ended up happening with that firm is it collapsed under a weight of debt. And the partners had guaranteed a lot of the assets with personal guarantees. So what ended up happening is that the banks came after the partners individually, but Mr. Kuhn wisely decided to relocate to the state of Florida and take all his money and put it in some ridiculously large house in Palm Beach County beyond the reach of creditors. And there was a lot of litigation about whether that was a fraudulent transfer or not. But ultimately, he sat there and put his hands up in the air and said, "Oh, protected by the homestead, you can't get my assets." And so that may be one reason you see people coming down from New York and spending tons of money buying huge properties. Because they're trying to protect their assets from creditors. And for the most part, they can do that. And it's up to the creditor to find out or discover or argue that that was a fraudulent transfer. And in certain instances that can be set aside, but the presumption starts off that the homestead exemption is valid. So that's just another challenge that people have to deal with. So that's essentially what I want to tell you about today. I wanted to take any questions. I don't know if Raina has any questions, or if there's anybody in the audience who might have any questions.
Yeah, thanks, Roger. If anyone has questions, you can either type them into the chat function, or if you want to show up on camera, you can also press the raise hand icon and join the webinar and ask questions that way too, if anyone's brave enough to do that. So we'll give people a couple questions or a couple minutes to do that. Also, this program has been recorded, and if anyone wants a copy of the recording or a copy of the PowerPoint, they can contact Maury Pramus, whose email I think is on here too, or you can email Roger. I'm sure he can get you to Maury's information as well.
Well, let me leave my contact information. You can always call me at the firm Haber Law here in Miami at 305-379-2400. My email address is rslade, that's S-L-A-D-E, at Haber, H-A-B-E-R.law. You can always email me after the program, and I'll be happy to talk with you or send you an email back.
Great, thanks, Roger. You had talked a little bit about garnishments. Are there any special considerations as to garnishments against companies or corporations rather than individuals?
Well, it's easier actually to garnish the money held by corporations because they don't have the exemption rights that individuals have. I mean, the Florida legislature is guards jealously an individual's money to the extent that it's believed it is utilized to support the family. Corporations don't have those rights. So if you have a judgment against a corporation and the corporation has a bank account here and there's money in it and it's a valid judgment, there's very few defenses.
Right, thank you. And you talked a little bit about the role of public policy and how that's a way for Florida not to recognize a judgment. What types of judgments have you seen that were ruled to violate public policy or might violate public policy of Florida?
Well, I think that you see that there's a lot of judgments that you see coming from places like the Middle East, in which the rights of women are not necessarily respected. And for example, that there's in the Taiwan case, there's no such thing as alimony, but there are countries in which literally women have no rights in divorce, and all the money goes to the husband, and all the assets go to the husband. The husband automatically becomes basically maintains custody of the children automatically without a trial or without a hearing. Those kinds of things are usually place red flags to the court system. Court system's not going to enforce that. Also, I mean, questions regarding service of process. I mean, there are some countries where all you have to do is publish things in the newspaper, and automatically, without a response, the plaintiff gets a judgment. I think the courts are circumspect about that, because we have here in Florida, like in a lot of places, you can give notice by publication, but you got to try the other route first. You got to try to serve personally. In some places, you don't even need to do that, or you just go down to court and you get almost like an ex parte. There's also issues regarding foreseeability and what is the defendant, judgment, debtor's relationship to the foreign state. So it's very popular, particularly in marriage situations where the parties get married. They live in a foreign country for a few years, but the wife never becomes a citizen. Then she comes back, and I say wife because that's most often the way it works, or has worked in the past, comes back to the United States and the husband gets a judgment. But meanwhile, the wife has no contact or any connection at all with the foreign country. So the courts are very hesitant about those kind of things. And there's a whole laundry list of things to look out for. But in the corporate context, it's more common that the foreign judgment is going to be recognized, or the out-of-country judgment is going to be recognized, because there's not those kind of issues.
All right, and then one final question that someone had was, when it comes to forum nonconvenience and filing motions to dismiss based on that, which kind of takes in some of these public policy considerations too, how important is the convenience of the foreign forum to an American court in Florida?
Well, that's an excellent question. I think the American courts are supposed to take that into account, because, and for those who are not familiar with the concept of forum nonconvenience, what it really means is what's the most convenient place for the case to be heard and go to trial? Where are the witnesses located? Where are the documents located? Yes, that is an important consideration, because if you're going to litigate a case in a foreign country, and most of the events which took place in the United States, the witnesses are here, the documents are here. I think once you get a judgment in a foreign country, you do have the right to raise forum nonconvenience as a defense, to say that was unreasonably difficult place for me to litigate. In other words, in my Taiwan case, the client would then have had to hire a lawyer in Taiwan, would have to travel to Taiwan, would have to find witnesses in Taiwan. That made it very difficult, and I think that is one of the considerations that the courts do take into account.
All right. Well, thanks so much. I think we're almost to the top of the hour, but this was very informative. Thank you, Roger, for sharing all of your expertise on the subject and introducing us to the difficulties with Florida law.
Thanks, Raina. I really appreciate your help, and anybody who wants to speak with me, they can offline, and thanks you all for attending. Appreciate it.
Thank you. Have a good afternoon.
You too. Bye.